Hi, and welcome to the latest of Number 8 Chambers Immigration Law Conversations. The idea of these conversations is just to have a short and hopefully relatively informal chat about current immigration case law and immigration law issues that we're facing as practitioners. Today, you have the benefit of three of us from Chambers. My name's Alex Barnfield, and with me are Emma Rutherford and Stephen Vokes, who is head of the Immigration, Asylum and Human Rights team at Number 8. We're going to have a chat about the recent Upper Tribunal case of Younas, a case which you, I'm sure, have read and is concerned with Chikwamba, Section 107B, and public interest in such Article 8 appeals in the UK. Now, these are meant to be just informal chats. They're not legal advice. They're not scripted. We're just having a chat between us with practitioners with experience of dealing with these sorts of cases and the issues around them. So nice to see you both. Emma, perhaps you can start us off, if you don't mind, with a summary of Younas and reminding us of the issues therein.
Yes, of course. This was a case involving, it's not a case involving Article 8, where Mrs. Younas came to the UK as a citizen of Pakistan. She came in 2016 on a visit visa whilst she was already pregnant, and whilst in the country then put an application in for further leave to remain on the basis that she'd been told at 30 weeks pregnant she couldn't travel because she had a history of miscarriages. Unsurprisingly, the Home Office didn't get round to deciding that application until after the child was born. So she put in a variation application in 2018 on the basis that she enjoyed family life in the UK with both her partner, who was of course the father of the child, and her daughter, who by that stage had been born. Her partner was a British citizen, and as a consequence, their daughter is a British citizen as well. The partner also had two British citizen children, a little bit older, from a previous relationship. The case was dismissed by the first tier tribunal on the basis that it was not disproportionate for her to return to Pakistan in order to apply for entry clearance. That was an interesting decision, I would say, because of course she spent most of her life living in the United Arab Emirates through, it would appear, her father. But unfortunately, while she was in the UK, she'd lost her right to return to the UAE. And the issue of whether or not she could be expected to return to Pakistan in order to apply state, it was accepted that there were in fact insurmountable obstacles to family life continuing outside of the UK, and that it would not be reasonable and proportionate for the family unit to be indefinitely separated. But the Secretary of State said it was reasonable for the family to be separated on a temporary basis whilst she returned to Pakistan in order to apply for entry clearance. Mrs. Younas said, well, it's not reasonable for my daughter to leave the UK for any length of time, and therefore we shouldn't be separated even for a short period. And in any event, I can meet the requirements of paragraph 276 ADE on the basis there are very significant obstacles to reintegration to Pakistan. And those were the issues that the tribunal had to contend with.
Yeah, and I mean, it's evident to anybody reading it that it's throwing up issues. The first sort of huge topic is any sort of dealing with the case of Chikwamba and those sort of applications. And Stephen, I wondered if you had some thoughts to kick us off on how that's going to help or hinder our use of Chikwamba, Section 107B, and whether you think the tribunal's direction on where it's going on entry clearance is changing.
Yes. What's happened in this tribunal decision is the tribunal has gone out of its way, so to speak, to revisit the whole question of Section 117B and in relation to the well-known case of Chikwamba. It probably comes as no great surprise to practitioners I'm sure if you look at the line of cases, that the tribunal has always been rather sceptical about this question of essentially whether the public interest requires you to return to your home country to skeptical in the sense of it's really put a gloss on the cases, first of all in the House of Lords of Chikwamba itself, but also, of course, in the recent well-known case of Yahoo, which said that the public interest might not require you to go back and claim entry clearance. The tribunal has always put a gloss on that by saying, it's always a factual circumstance as to whether you were bound to get entry clearance, and it's been rather difficult to persuade a tribunal that you would, in fact, qualify for entry clearance, and therefore there would be no point in the public interest in you having to return to your home country. One of the points always made by a Home Office official is, well, the circumstances may have changed, the rules may have changed, whatever. In this case, what happened is, and this is perhaps a new development, what they did was look at Mrs. Younas' immigration history and come to the finding that at no time was she actually going to leave the United Kingdom, although she came here as a visitor. And so what they said was, one now has to look at the statutory constraints of section 117B1, namely the maintenance of immigration controllers in the public interest. And that, they said, was not the case when Chikwamba was decided. For my view, and therefore her immigration history weighed against the fact that she was bound to get entry clearance. The difficulty with that in this case is, of course, as Emma has pointed out, there's a child involved. And therefore, one has to look, what some other practitioner said, that the influence of the best interest of the child, which of course is a statutory construction now. The tribunal appear to have glossed that to a certain extent by saying in all cases you have to look at 117B1. Yes, that might be true, but in all cases involving children, one would actually have to look at Section 71 of the Immigration Act 2014 or Section 90 of the Immigration Act 2016, which specifically puts into statute that the best interest of the child should be considered. I think it's fair to say the tribunal did go on to look at the best interest of the child to a certain degree, but in the context, because they had to, because of the relevance of Section 117B6, but in the context of a finding they made, in paragraph 65 of the judgment, if anyone's interested, that factually she would only be out of the country and her child would only be in the country for 4 to 9 months. Because that would clearance application would take from Pakistan. You know that, in fact, the Secretary of State has quite often said in entry clearance cases, when somebody is required, I'll take my glasses off for this, when entry clearance is required, hey, you can just go back and say, arguing there's no breach of Article 8 rights, because you can just go back and apply for entry clearance and it will take a couple of months and that will be it. Now, the difficulty in this case is this approach by the tribunal open the doors in every single case before the tribunal of assessing how long an entry clearance application would take, assuming, of course, as what happened in Younas, is that you meet the rules for entry clearance. The real difficulty I find legally is the tribunal paid no attention to a case called SB Bangladesh against the Secretary of State. I'll give you a citation for those of you who want to read it, which is 2007 EWCA Civ 28, where you have exactly this situation, where in fact this lady, SB, the Home Office, the first tribunals, the Immigration and Appeal Tribunals, took the view that basically if she went back and claimed entry clearance, she would only be out of the country for a short period of time, and therefore her family life wouldn't be disrupted. Lord Justice Ward, giving the opinion of the court, said that, and this is the only legal point in the case, the tribunal were wrong to take that into account, paragraph 21, because essentially, at paragraph 23 of the decision, he says it would be debatable and speculative to do so. And at paragraph 24, he's even firmer by saying it would refer to to unfairness to the appellant, because for three reasons he gave. One, the ECO might take a different view on facts and law. And I might say, as everybody knows, that very often happens because they do not understand the law or the facts. Secondly, the rules might have changed. And thirdly, the facts may have changed. And therefore, the court was very clear, senior court, that in fact, it would be an error of law if the tribunal indulged in making a finding as to how long an entry clearance application would take, because it would be entirely speculative. And what concerns me and disturbs me to a considerable degree is that in the present case we're discussing, there's actually no mention of SB Bangladesh. Now, I know the appellant was only represented by a legal assistant, I believe, a legal representative. However, I would have thought it was incumbent of the Secretary of State to actually mention SB Bangladesh, or indeed the tribunal to do its own researches, because it now appears that, in fact, without explanation, they've decided to diverge from this case and find that an assessment of reasonableness under section 117B6, actually in relation to whether it's reasonable to go to for a child to go abroad, should actually take into account how long mother and child, because they accepted the child would have to stay with mother because it was a young child, would need, how long they would be out of the country before they returned. There is a reference, and I end by saying this, there's a reference to actually making decisions in the real world following the well-known case of KO Nigeria. But of course, SB Bangladesh precisely deals with cases in the real world. Cited in paragraph 24, that of his decision, he names the factors which can actually influence an entry clearance application, and therefore it would be speculative, as I said before, for a tribunal to engage in that kind of reasoning. Present tribunal in Younas engaged in. I think for now I'll leave that there, because, as I say, there does seem to be a rather stark contrast here.
Yeah.
And I'll leave Emma to say what she wishes to say about the case.
Yeah.
Thanks very much, Alex.
No, thank you, Stephen. I mean, the next, perhaps beyond those points, the next sort of obvious thing to think about is where that leaves us with Zambrano. And I know in your summary of the facts, Emma, you also mentioned 276 ADE.
Yes.
If you had any thoughts on those.
Well, dealing with the Zambrano point first of all, I mean, the tribunal looked at Zambrano. It was an alternative argument raised by the appellant in that case, arguing that, well, my child's going to be compelled to go to Pakistan with me. And the tribunal, in fairness, accepted in their findings of fact that the daughter would, in all likelihood, leave the UK with mum and go and live in Pakistan until such time as entry clearance was granted with mum, based on her young age, the fact that mum was primary carer, and also based on the fact that father had work commitments, and obviously if he's going to meet the financial requirement, was going to have to continue to work to enable them to come back. But the tribunal looked at this argument of Zambrano and this argument that, well, if the child is going to go to Pakistan with mum, the child is being compelled to leave the UK. And they considered in the judgment what's said in Patel in the Supreme Court about Zambrano, and noting that the Supreme Court had not agreed with the Court of Appeal about this. Well, if there's an element of choice, because of course the child could always stay with dad, then that wouldn't engage Zambrano principles. The Supreme Court, of course, in Patel found that if in reality the child is going to have to go, then Zambrano principles can come into play. But of course, this didn't ultimately help the appellant in Younas, because what the court said was, well, be going temporarily to Pakistan, they're not going to be there indefinitely. And yes, that is their union rights, but let's be realistic here. This is a child who's maybe 3-4 years old by this, it could be 3, I think, and is at nursery school. This child is not going to be exercising her treaty rights independently of her parents in any event. And ultimately they concluded that in light of what was said in Patel about you've got to look at the real world situation, and you're not just looking at the theoretical set of circumstances, all that was being said here was this child for a period will have to leave the UK with mum, or will leave the UK with mum, and will be deprived, yes, of their right as a union citizen, but only on a theoretical basis, because the child will not be exercising those rights. So they find that in this scenario where you're looking at temporary separation, in theory, no, the child will be leaving the UK and therefore the union territories as a consequence of the decision. They did note that none of the jurisprudence in respect of Zambrano looks at this position where you're talking about temporary separation. All the case of Zambrano, Patel, we were talking about children who are going to be leaving indefinitely, but the upper tribunal seems to have come to the conclusion, that a short separation and a short removal from the UK, or requirement of getting around these decisions in relation to the decision taken and the approach taken in respect of get around the Chikwamba point.
Mm.
I think the other thing that comes out from the case is also the 276 ADE aspect as well. And there's just perhaps a couple of points that are worth making about that. And that's earlier on in the judgment, because what the appellant said in first case is, well, actually, let's not worry about these Chikwamba Zambrano arguments. I actually meet 276 ADE, and therefore, in light of TZ Pakistan, I meet the immigration rules and it's a breach of Article 8. So as an alternative to try and get round this point, they could go back temporarily. And the tribunal considered those arguments. And just a couple of points that are worth noting in relation to that consideration. And the first is the tribunal emphasised that they are looking at position as of the date under 276 AD at the date of application. And they said, well, at that stage, going back to 2016 when the initial application was made, Mrs. Younas had not been in the UK for very long, and at that point her return could have been back, and she claims it was her intention to go back to the UAE at that stage. And they said, well, she'd lived there all her life, that there's no difficulty in her reintegrating there. They then made findings in the alternative that she could reintegrate into life in Pakistan, not entirely accepting her evidence in respect of that point. But then also flagged up just one point that I think is worth noting for future cases involving 276 AD in this point about temporary separation, that they hadn't heard argument on the point about whether 276 AD very significant obstacle arguments would be affected by the fact it was a temporary location rather than a permanent separation. So perhaps envisage relatively normal life in the short term in a country, but maybe not in the longer term or the medium to longer term. They'd have greater problems in re-establishing themselves. I don't think that's what 276 AD is intended to look at. Whether I think looking at 276 AD, it very much is looking at a wholesale relocation to a country on a long-term basis. But it's interesting, I think, that the tribunal have considered that as a potential issue that perhaps we need to be alive to when we're running these arguments in cases where entry clearance is a potential option that's available to an appellant. No,
very good. And I think that's a good, if you like, a practical note to sort of start to wrap things up. I don't know if anybody had any other practical steps to think about in these sorts of applications or in dealing with Chikwamba going forward before we wrap up.
2 points I would make. One, that it seems to me that on a Chikwamba style argument and an entry, and also on an entry clearance, you go back and claim entry clearance. It's important that SB Bangladesh is cited, because that to me is still decided case law, which the tribunal haven't dealt with. And some interplay between section 117B1, and that is, of course, the question of immigration control and the public interest, and section 11B6, because it seems to me that the tribunal haven't distinguished the situation of children in the light of their best interest, which is a statutory requirement, against the weight you would give to breaches of immigration control. Hopefully that's reasonably clear.
Yeah. Well, very good.
Yeah, and I think from a practical, when and thinking about the evidence that's required, one of the things the tribunal look at is, of course, the best interests of this particular child, and say, well, it's the best interest to stay in the UK with mum and dad and be a family unit, but actually there's no detriment to this child in returning to Pakistan for a short period. There's no way to be just live in her mum's country of nationality and just at that age, but she's going to be with her primary carer in her mum's country of nationality, with potentially extended family who they found would be available in Pakistan, and certainly that they'd have some contact with. So those are things that you need to look at, I think. What kind of evidence have you got to show that there will be a detriment to this child in these particular circumstances in going back to the home country, even for a temporary period?
So focus on the specifics, yeah.
Yeah, that's very well put, I think.
Very good. Well, thank you. And it's been great to talk to you both. I was thinking earlier, it seems like a long time since we had these sorts of chats over a cup of tea in person in chambers, but
yes, absolutely.
It's a bit of a shame, but perhaps things will return to being a bit more normal soon. But anyway, thank you, Stephen, Emma. Nice to chat to you both. Stay safe, and thank you for watching. Stay tuned to our website and our Twitter account for more updates and more of these immigration law conversations, and stay safe.
Thank you.